The problem is the length of time that the motion has been, so she would have, 5 years, she would have, August of 2025 would have been the end date. We're not to August yet, so we're still okay. I've got a year. Ms. Smith, in cause number 26 DCCR 0870, you're charged with the state jail felony offense of possession of a controlled substance, methamphetamine, from May 1st of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? So we're gonna go to, I don't need to pre-sentence report, I don't guess, on these new ones. Correct. And then in cause number 26 DCCR 0871, you're charged with the state jail felony offense of theft of property with previous convictions from May 1st of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with? That indictment also alleges that you were previously convicted of theft August 1st of 2001, and then February 7th of 2003, and then August 12th of 2005, and then February 6th of 2013. And are all of those prior convictions for theft true?
Yes.
And did you enter your plea of true freely and voluntarily?
Yes.
In each of these new cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And it looks like the agreements that you've reached in each of these cases are for 2-year terms in the state jail prison that would be probated for 5 years. There would not be a fine. I don't see that y'all wrote on here safety, but that's part of the agreement, correct?
Yes, ma'am.
And it's also part of your agreement, and I'm going to write it in as well, that you enter and successfully complete the safety program. Is that your understanding?
Yes.
State tenders number 1 in each of those cases?
No objection, Judge.
It's admitted in each case. Is there any evidence that Ms. Smith is not competent?
No, Judge.
All right, Ms. Smith, in each of those cases, I'm going to find that you entered your pleas of guilty and then true freely and voluntarily. Find sufficient evidence to find you guilty. And cause number 26 DCCR 0870 finds you guilty at this now of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but that'll be probated for 5 years. You're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the safety program. Cause number 26 DCCR 0871 finds sufficient evidence to find you guilty, and at this time finds you guilty of theft of property with previous convictions. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but I'm going to probate that for 5 years. You're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the safety program. Then I need that sentencing back, please. In cause number 19-33472, you were previously here in court. You entered pleas of true to counts 3, 5, and 6 in a motion to revoke your probation. You're on probation in that case for the state jail felony offense of theft of property. And that was from August 30th of 2020.
Same question, Judge. I was going to ask the court's guidance. I don't know that because it's that level of an offense, if the court can extend it, I would hate for it.
I can extend a state jail felony up to 10 still.
Okay.
The problem is the length of time that the motion has been, so she would have 5 years, she would have, August of 2025 would have been the end date. We're not to August yet, so we're still okay. I've got a year.
Yes.
So
Right,
we're
and
okay.
it was filed in May of 25, so it actually
told it right before it technically expired.
Yeah, but even with tolling, if you have a year past that, then
You're
you're
just shot.
done.
Right.
So we're good. Okay. So we've reviewed that pre-sentence report. We talked about this last week, I think, reset it, and it's everyone's suggestion that I continue this probation, obviously extend it and order safety as a condition. Is that correct? And Mr. Riley's here, and I'm not Mr. Riley, sorry, Mr. Kitchens is here. And you are the probation officer for Ms. Smith, and is this your recommendation?
Yes, that is correct.
Okay, thank you, sir, for being here. Sorry, I called you the wrong name. So Ms. Smith, I am going to find in cause number 19-33472 that you entered those pleas of true freely and voluntarily. Find sufficient evidence to find you guilty. Or was she already guilty on this? Was it
That was a straight.
It was straight.
It was a straight.
it was a straight, so find sufficient evidence to revoke the probation. However, I'm going to follow the agreement that you've made and continue you on probation. I'm going to extend the probation in this case for 3 years. I'm going to order in this case that you enter and successfully complete the safety program. So if you do all of this correctly, you are being given a chance of a lifetime today. You've already seen my response and that I don't really love all of this, correct? What that means is that if you're back in here on a motion to revoke, I'm going to look at all of this and wonder what I was thinking. And it's going to make me really mad that you made a fool of me for going along with this. So please don't do that. Okay. Take advantage of SafeP, get clean, and then you can serve all of these sentences while you're out on probation instead of in the state jail prison, which is where you'll end up if you violate. Okay.
Judge, may I just, I'm sorry, add one thing for the
Yes.
record for Ms. Smith. As the court told you, and I mean no disrespect by this, but she's gonna be just as mad at me for asking her to give you the chance as you. And so when you come back, if you come back, I hope you don't, other than to tell if you're doing great. I will be asking Judge that these run consecutive. And you know I've been here since 2020. It's still gonna be me here in 3 years. So that would be the recommendation of the state at that time, Judge. I hope it doesn't come to that, but
I do too.
that's why we're giving her this
Good.
opportunity.
Take advantage of this opportunity. We all want you to be successful.
Thank you.
I'm handing you the trial court certification in all 3 of those cases that shows that these were agreements that I followed. So you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, ma'am.
Thanks.
Thank you. Love it. Thank you.
Ma'am, yes, okay.
In this courtroom hearing, Ms. Smith walked into court facing serious consequences after being charged with 2 new felony offenses: possession of methamphetamine and theft of property with previous convictions. When the judge questioned her, Smith admitted guilt to both charges and confirmed that her pleas were made freely and voluntarily. The court also reviewed her past theft convictions, showing a long history of similar offenses. Instead of sending her straight to jail, the judge accepted a deal that gave her 2 years in state jail, but suspended the sentence for 5 years of probation. However, the judge made it clear this was not an easy way out. The biggest moment came when the judge addressed Smith's previous probation violation. The court found enough evidence to revoke her probation, but surprisingly decided to give her another opportunity. The judge extended her probation for 3 more years and ordered her to complete a treatment program. The warning from the bench was powerful. The judge explained that this was a rare second chance, and if Smith returned to court again for another violation, the outcome would be completely different. The judge's message was simple: take this opportunity seriously, get help, and avoid ending up behind bars. The prosecutor also added that if she failed again, they would push for consecutive sentences. This hearing showed a judge balancing accountability with one final chance for change.